Welcome back, everyone. Hope you had a wonderful lunch. And to our great C-SPAN audience, here is what's going on at the National Constitution Center today, the most exciting Bill of Rights Day in memory. Today, December 15th, is the 223rd anniversary of the Bill of Rights ratification and the 225th anniversary of its proposal. And this is the day that we at the National Constitution Center open a new gallery displaying one of the 12 original copies of the Bill of Rights, along with rare copies of the Declaration of Independence and the Constitution Center. I should say I am Jeff Rosen, the president of the National Constitution Center, which, as our hardy audience knows, because I've introduced it 2 times already, is the only institution in America chartered by Congress to disseminate information about the US Constitution on a nonpartisan basis. We had the idea of summoning the best constitutional thinkers in America from the left and the right and all sides of the political spectrum who've written the most interesting books about the Constitution for the Constitution Center's first ever Bill of Rights book fair. And this is the 3rd installment of this wonderful experiment. C-SPAN viewers can tweet their questions to @ConstitutionCenter, ConstitutionCTR, using the hashtag NCC Bill of Rights. And our hardy and loyal and intelligent and engaged audience can now engage in the 3rd installment of a conversation that flows so naturally that all of us are learning about the historic sources of the Bill of Rights, about the philosophical disputes about exactly what it stood for from the beginning, and about its historic development and contemporary meaning. So we started the morning talking about the meaning of the First Amendment and the central battle over whether seditious libel, namely whether you could criticize government officials, was or was not permitted by the First Amendment. We learned James Madison thought it was not because free speech was a natural right, but that it took the Supreme Court until the 1960s to recognize that principle. Then in the second conversation, that great conversation with Yuval Levin, we saw that the discussion between Madison and Jefferson and John Adams was part of a broader debate between the acolytes of Thomas Paine, who advocated a natural rights view of the Constitution, and those who were more sympathetic to Edmund Burke and favored evolution and continuity and tradition. And now in this 3rd installment, we've just got a blockbuster debate because we have with us the author of a fascinating and important new book. He is Timothy Sandefur. He's written The Conscience of the Constitution, the Declaration of Independence, and the Right to Liberty. And in this book, he argues that the tradition of Thomas Paine that we heard about in the last show really was at the core of Jefferson's Declaration, and his view should be at the core of the Constitution. And the judges today should construe the Constitution in light of the Declaration's presumption of liberty and should strike down laws that are arbitrary, that arbitrarily interfere with people's freedom as long as freedom doesn't harm others. And he criticizes the court for being too deferential, and in particular, he criticizes the tradition of judicial restraint represented on the Supreme Court by Justices Oliver Wendell Holmes and Louis Brandeis on the left, by Justices Antonin Scalia and Robert Bork on the right, and represented in the Academy by Professor Kermit Roosevelt of the University of Pennsylvania, who Timothy Sandefur has some vigorous and provocative criticisms for, and we're just going to have a great debate about what did the framers intend? Was it a presumption of liberty where courts would be active in invalidating laws that infringed unenumerated rights, rights that weren't written down in the text of the Constitution? Or did they have a presumption of democracy where generally it was up to legislatures, not to courts, to define liberty, and courts should be restricted to striking down only those laws that violated clearly enumerated constitutional rights? Very brief introduction for our 2 great scholars. Timothy Sandefur is a principal attorney at the Pacific Legal Foundation and heads of the foundation's Economic Liberty Project, which protects entrepreneurs against abusive government regulations. He's an adjunct scholar with the Cato Institute and author of 3 books, including this most recent one. And Professor Kermit Roosevelt is a scholar at the Constitution Center, as well as professor of law at the University of Pennsylvania Law School, specializing in constitutional law, a clerk for Judge Stephen Williams and Justice David Souter, and he's written 4 books, including Conflict of Laws and the book that's the object of Timothy Sandefur's ire, and that is The Myth of Judicial Activism, Making Sense of Supreme Court Decisions. Please join me in welcoming Timothy Sandefur and Kermit Roosevelt. Tim, I'm so glad that you're here. You've just written a passionate and vigorous defense of the Constitution of Liberty. You begin by saying that constitutional history has always hovered in the mutual resistance of two principles, the right of each individual to be free and the power of the majority to make rules. Tell us about this principle, which you call the primacy of liberty. You say it's expressed in the Declaration. It was embraced by abolitionists. The Constitution should be interpreted in light of it. How should judges interpret the Constitution in light of the presumption of liberty?
Well, the idea of the presumption of liberty is the idea that when we look at political institutions, a constitution or a legal system or what have you, we start with the premise that people own their own lives and have the right to direct their own lives without arbitrary interference by somebody else. Now, if they're harming other people, of course, that deprives the other people of their right to run their own lives, and so there's a role for government to intervene to protect people. But we start with the presumption that people are free with certain inalienable rights, and they create government to protect those rights. And if the government abuses those rights, the people have the right to alter or to abolish that government. That's the presumption of liberty. Our basic presumption is people should be free unless there's good reason to restrict their freedom. As opposed to what I take to be the general view in the academy today, lawyers, judges, and law professors predominantly in America today believe that freedom is a present that the government gives to you, that you are as free as the government allows you to be, and that you are only free if the government says you are. We find this theme throughout our law in the form of permits to use your property or to earn a living as you choose, laws that say you're not allowed to build on your property, you're not allowed to run a business until you first get the government's permission. And we also find it in the realm of constitutional law, particularly in what courts call rational basis scrutiny, which is the test that the court will use when determining whether a law is constitutional or not in some areas of our law. Under that theory, the court presumes that the law is constitutional and requires the plaintiff to, quote, disprove every conceivable basis for the law, end quote. Now, you laymen out there probably are thinking, well, gosh, it's not possible to prove a negative. That's right. Nor is it possible to disprove an infinite number of negatives. And yet that is what courts require you to do when you go to court to defend your property rights or your economic freedom against arbitrary government interference. So my argument is that really the basic thesis of my book can be summed up by a phrase from Justice Thomas, who said in a case some years ago, something has gone seriously awry with this court's interpretation of the Constitution. But what has gone seriously awry is that particularly intellectual elites, have disregarded this idea of the primacy of liberty, the idea that people are free and have the right to run their own lives unless there's legitimate reason for restricting them.
Great. A strong statement of a provocative thesis. The primacy of liberty means the majority has no preeminent right to rule. It must justify any limits it imposes on individual freedom by reference to some genuine public principle, such as preventing people from harming one another. Kim, I want to start with history. And Tim is making a claim about original understanding. And he says that the framers would have understood the Declaration of Independence to be law and to embody this harm principle, and that judges today should enforce it. But Justice Scalia and others have disputed that. Scalia said the Declaration is not part of our law, and he says the rights that the Declaration calls inalienable are not a legal prescription conferring powers on courts, and has expressed disdain for what he calls the Thoreauvian, you may do what you like so long as it does not injure someone else's beau ideal. Basically, Scalia says that Tim and his supporters are trying to read their own philosophical preferences, or those of John Stuart Mill or Thomas Jefferson or Thomas Paine, into the Constitution. What is your reading of constitutional history, and who has the better historical argument?
Well, let me start by thanking you for having me here, thanking all of you for coming, and thanking Tim actually for such a thoughtful and sustained discussion of my book, although I encourage you to buy the book rather than just relying on his discussion. But as to your question, Jeff, I think that the Declaration is not law. I have a fair amount of sympathy for the idea of natural rights. I have a fair amount of sympathy for the idea that rights precede government. that we create governments to protect and secure our rights. But I believe that the government does, the Constitution does, give us judicially enforceable rights. So that if you're going into court and you're asking a judge to strike down some law on the basis of a right, that should be a constitutional right. That should be something you can find in the Constitution, not something that pre-exists government. Now, I have something somewhat more provocative to say, actually, also, which is that I'm not a huge fan of the Declaration, having thought about it a bit more. Because I think that the Declaration is fundamentally not really about liberty, but about self-determination. So it does have this political philosophy. We create governments to secure our rights. What happens if the government is abridging those rights in an oppressive way? The Declaration's idea is not you go to court to get a judge to strike that down. The Declaration's idea is you alter or abolish that form of government. And we've seen that idea in American history, not in the Lochner era, not in judges striking down rights in the name of liberty of contract. We've seen that in the Civil War. So in my view, the Declaration is not what we should be looking to as the statement of our foundational values. It's certainly not law. The Declaration gives us a political philosophy that finds its full flower in the Civil War, which I think you can consider the Second American Revolution, and really ends there, because we don't believe in secession anymore. We don't believe in this kind of right of self-determination. And if you're looking for our fundamental values, you should be looking instead, I think, to the Gettysburg Address. And
Wonderful.
actually, if I could just say one thing.
Please. Is
Here,
that the National Constitution Center pocket
this
constitution?
is now, so I was criticizing Tim a little bit. I suppose now I'm going to criticize you.
Fine, but I'm going to...
If that's okay.
In that case, I'm going to take out my pocket constitution, too.
And
it looks like it's time
I
for...
have it memorized.
Well, just to make it a fair fight, here's yours. And it looks like this is a little like constitutional smackdown.
well, right, it's like a lightsaber. But no, but all I'm going to say is,
yes.
You've got the Declaration, you've got the Constitution. I want you to include the Gettysburg Address.
Oh, okay. Done. Bravo. Well, since this was not a setup, and this is a plug for our great new pocket constitutions, which have an introductory essay by me and David Rubenstein, who's lent us the Declaration of Independence, which Kim just expressed disdain for. And the point of this essay is to tell the story about how the rights that were implicit in the Constitution, or rather, promised in the Declaration, are implicit in the Constitution and codified in the Bill of Rights. But this quite uplifting essay doesn't really answer the question that Kim and Tim were talking about, which is, were those unenumerated rights in the Declaration judicially enforceable? In other words, no one's disagreeing that the rights of free speech, of conscience, and so forth are enforceable by courts. Tim is claiming, though, that there are certain unenumerated natural rights that are not listed in the Constitution, that are protected by the Ninth Amendment, which says that the enumeration of certain rights shall not be construed to deny or disparage others retained by the people, should be enforced by judges. And this is the biggest constitutional dispute of the 20th century, basically. Who's right, Kim or Tim? Now, Tim, if you will, respond to Kim's provocative statement that the Declaration is not law, that basically Yuval Levin in the show just before this one agreed with Kim in this sense. He said Thomas Paine would not have counted on courts to enforce natural rights. He would have expected people to rise up and exercise their right of revolution to alter and abolish government. So what's your response to Kim's idea the Civil War was the right response, not courts? I think you do have a response because you say that the abolitionists actually went to court, so tell us about that.
Well, that is true, but remember the Declaration says, when a long train of abuses pursuing invariably the same object evince a design to reduce us under absolute despotism, it is our right, it is our duty to throw off such government. Like I said, I've memorized it.
Nice.
And we only can find out if that is the case after having exhausted the lawful routes for securing the rights with which government is entrusted with securing. So if, for example, a police officer wrongly searches my home, is a proper response rebellion against the government? No, I have a constitutional guarantee that I can go to court and seek enforcement of. And in fact, the Founding Fathers, when writing the Declaration of Independence, they took every lawful means at their disposal before taking the final revolutionary step of declaring independence. So although, of course, I agree that the right of revolution to secure individual rights is an inherent part of our system of government, it's, of course, the last thing that you do. Before then, you exhaust the mechanisms that the law provides for protecting your rights, and one of those is the court system. Now, do the courts have the right to enforce our unenumerated, so-called unenumerated rights? I object to that term because the Constitution guarantees liberty. The word liberty is enumerated. It's written into the Constitution. And the word liberty doesn't come in discrete particles. Liberty is a broad freedom to do as you please so long as you harm no other person. So I would object to the idea that, for example, my right to run barefoot through sprinklers on a hot summer day is an unenumerated right. In fact, it is enumerated. It's part of my liberty. It's in the Constitution, and no government has any right to arbitrarily take away from me the right to run barefoot through sprinklers on a hot summer day. If the government tries to do that, I go to court and I say the government has deprived me of liberty without due process of law. Now, if the government denies me redress and denies all of us redress over and over again, and a long train of abuses evinces a design to reduce us under absolute despotism, then we take the step of revolution.
So, Tim, would a law prohibiting the government from having us tiptoe through the tulips on a hot summer's day violate the liberty protected by the Constitution?
Well, yes, sure, it restrains your liberty. The Constitution does mention liberty. The Constitution mentions a bunch of other things, too, though. So I don't think it's fair, really, to pose the question, is liberty or democracy the fundamental constitutional value? You know, the Constitution does mention liberty. It mentions equality. It doesn't mention, but arguably also protects privacy. And the thing about many of these constitutional rights or constitutional values, which I think Tim brings out so well in his opening to this book, where he discusses Abraham Lincoln's parable of the wolves and the sheep, is that when you restrict one person's liberty, the liberty of the wolf, in Lincoln's view, you're enhancing someone else's liberty, the liberty of the sheep. And the sheep will say, hey, the government has increased my liberty. Isn't that great? And the wolf will say, hey, the government has restricted my liberty. Isn't that terrible? And the fundamental question that we're asking here, in my view, is who is going to decide, is the wolf right or is the sheep right? When do we trust the democratic process to do that? When do we trust the democratic process to reach the right result in promoting and protecting our rights? And when do we think judges should step in? Because the judgment calls that some of these questions require, it's not a purely legal question. You know, so the government has some reason for restraining liberty. Maybe it's that it's going to enhance the liberty of someone else. And who decides whether this is a net increase in liberty or not? Maybe a judge is good at making some of these decisions. Maybe sometimes there are reasons you can't trust a legislature. But in many cases, and I would say most, leaving things up to the democratic process is the wiser way to go.
So the debate is joined. Tim, I want to get into the specifics. One of the many rich and provocative chapters here that you have is the Civil War and the incomplete Reconstruction. And there's a tremendous amount in here, but if I can try to summarize it and have you react to it. You say that there were abolitionists, led by Frederick Douglass, who believed that even though slavery seemed to be explicitly contemplated in the Constitution in the 3/5 Clause and elsewhere, in fact, slavery violated the Constitution properly understood in light of the Declaration of Independence because people residing in the U.S. when the Constitution were ratified were citizens. The Constitution protects all citizens and their rights to life, liberty, and property. Slavery violated those rights, and therefore slavery was unconstitutional. There are also more sophisticated arguments involving the comedy clause of Article 4, where John Bingham, the author of the 14th Amendment, thought it contained an ellipsis and basically said the citizens of each state are entitled to the privileges or immunities of citizens of the United States in the several states, and basically that there was a basic quantum of rights for U.S. citizens that was being denied to slaves. You then tell the story, forgive me for summarizing, but I'm just going to put it on the table. You then tell the story about how there was a civil war fought. Lincoln has his Gettysburg Address. Congress wants to protect the rights of the freedmen that had previously been denied them. It passes the 13th Amendment, which turns 150 next year, and we're going to have a 13th Amendment, also lent by David Rubenstein, and have a year-long celebration of the 150th anniversary. And then the 14th Amendment, which says that the privileges or immunities of United States citizenship shall not be infringed. And you talk about how this clause, which the framers, led by John Bingham, thought would bind the states as well as the federal government, was eviscerated by the Supreme Court in the Slaughterhouse case. Amazingly, you suggest that the lawyer for Louisiana was actually the same Pennsylvania Supreme Court justice who'd written judicial decisions denying liberty before the Civil War. So you make a strong case that the abolitionists thought there were basically implicit natural rights that were being violated by slavery,
That's right.
but they still thought that it took a constitutional amendment to explicitly
Right.
protect those rights. So what is your basis for concluding that John Bingham and the other framers thought that the 14th Amendment included not only the rights enumerated in the Bill of Rights and the common law rights that were listed in a case called Corfield and Coryell, which you note, like the right to travel and the right not to have to make and enforce contracts, to sue and be sued? Why do you think that that also enabled judges to decide what they thought was arbitrary and which deprivations of liberty were unjustified?
Right. Well, now this is, I think, one of the most fascinating stories in the history of American constitutional law, and it's often skimmed over, I think, in constitutional history because we tend to go straight from the framers to kind of the jump to the Civil War, post-Civil War era to the present day. And really, the 1830s was a time of intellectual ferment like we've rarely seen in this country, with basically the construction of the pro-slavery constitutional theory and then the anti-slavery constitutional theory, led chiefly, I argue, by John Quincy Adams. After he had left the presidency and was in Congress, he was really the godfather of what I take to be the libertarian interpretation of the Constitution, the anti-slavery theory that eventually climaxed in the ratification of the 14th Amendment. And it's a fascinating story why it was that Douglas and his followers in the abolitionist movement thought that slavery was already unconstitutional before the 13th Amendment. It's an interesting argument. I try not to take a position on saying that they were exactly right or exactly wrong, because I don't think there was a right answer at that point. That's just why an amendment was necessary. But by the time the amendment, the 14th Amendment, came around, what had happened was the Southerners were out of Congress, the war was over, the South had been it was laid waste by the war, and the radical Republicans saw this as their opportunity to put their constitutional theory permanently into the Constitution. Not so much to say that they were changing the Constitution, but to restore what they thought had always been the Constitution, and that is to restore the principle of the primacy of individual liberty, among other things. And so the 14th Amendment begins, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now that's incredibly important because until that time the Constitution had never defined citizenship, believe it or not. And the whole idea of states being sovereigns, which unfortunately you still even hear people say today, the idea that states are sovereigns is obliterated by this clause because what sovereign can't define its own citizenship? States have no authority to declare who their own citizens are under this amendment. The state of California has no role in deciding whether or not I'm a Californian. That's amazing, right? Then the second clause says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Well, what are these privileges or immunities? It's a legal term of art, and when you look back at the legal history, it's defined in Corfield versus Coryell 50 years beforehand, and in other prior legal precedents and legal scholars who had explained that these included these individual rights, these natural rights, these common law rights that were now protected against the states. Now, why do courts have a role in enforcing them? The Constitution says no state shall make or enforce any law which shall abridge these rights. So if the state comes to me and says, I'm going to take away your federally protected civil rights, I'm going to take away your freedom of speech, for instance, I'm going to pass a statute that says Tim Sandefur may no longer express his opinions on politics. Well, I go out there and I express my opinions on politics. I get arrested by the sheriff. I get dragged to jail. What am I going to do? I'm going to go to court and I'm going to say, Your Honor, this law has deprived me of my privileges and immunities. And it has deprived me of liberty without due process of law. Because whatever the state passed to take away that freedom is invalid. It can't qualify as a law. And therefore, I'm deprived of liberty without due process of law. So of course I'm going to go to court. And what's the judge going to say? He's going to say my imprisonment is illegal, I hope. Right? We talk about this idea of where do the judges get their authority? The judges get their authority because their role is to interpret the law. And these rights are part of the law. That was well known to the American founders in the 1780s because before the Bill of Rights, all rights were unenumerated. The rights protected by the English common law for at least 200 years, before that even, were all unenumerated rights. English courts had upheld the rights of British subjects long before the American Revolution, and they did so even though there was no written constitution in Great Britain. There's no Bill of Rights. These were all unenumerated rights. The Founding Fathers were very familiar with the idea of unenumerated rights. That's why they wrote the Ninth Amendment to protect rights not specifically listed, and the 14th Amendment in the 1860s was written in order to protect the privileges and immunities of citizens of the United States.
So
That's a short answer.
it was a long question, and it was an excellent answer. And now, Kim, so we're in the late 19th century. The 14th Amendment has passed. The Supreme Court has basically eviscerated it in the slaughterhouse cases by saying that its intent, which was to apply the Bill of Rights against the state, can't be achieved, and as a result, it took almost another 100 years for that to happen. But nevertheless, the courts, and particularly the Supreme Court, went on to do exactly what Tim is suggesting, striking down basically economic legislation in the name of the liberty protected by the 14th Amendment. So in the famous or infamous, depending on your point of view, Lochner case at the beginning of the 20th century, the court invalidated New York's maximum hour law for bakers and struck down a whole bunch of other laws. There was such an objection to this among progressives that Franklin Roosevelt won election on his opposition to judicial activism, and eventually the court retreated, switched its position, and said they're going to generally uphold economic regulations unless they're wholly irrational, but they're going to enforce individual rights like free speech and so forth more aggressively. Tell us, Kim, please, why the progressives thought that the economic cases such as Lochner were not faithful to the Constitution, what the danger of that sort of judicial activism is, and why the 19th century cases that Tim cites in support of that kind of judicial activism should not be followed.
Well, that's a big question.
That's what we're all about here today.
And I'll try to give you a relatively short answer. But I said before that the Constitution protects a lot of different things, and frequently when the legislature acts, when the government acts, it's promoting one person's constitutional rights or constitutional interests at the expense of another's. So you can imagine a worker, let's say, working in a factory for maybe 14, 16 hours a day, sorting and cutting fabric, let's say. And maybe, being exposed to harmful dust in the air or something because the working conditions aren't that great. And maybe the doors are locked because the owners think that workers are stealing things. And this is a 13-year-old girl, let's say. So how much freedom does she have? Well, when the building catches fire and the doors are locked, she has the freedom to choose whether to die from the smoke and flames or to jump from the window, as many of them did. This is the Triangle Shirtwaist Fire. And if the government comes along and says, no, you can't do that, you can't strike that bargain, you can't work 16 hours a week, you can't have these working conditions, you can't pay these people so little money that they have to work 16 hours to make ends meet. It's reduced liberty, certainly. In a formal sense, you could say it's reduced the liberty of contract of both sides, which is what the Supreme Court actually says in the Lochner decision. It says that the New York legislature, by setting maximum hour laws for bakers, had infringed on the liberty of contract of both the employer and the employee. But if you think about it in a substantive sense, in terms of what kinds of freedom these people have to lead meaningful and fulfilling lives, to pursue their vision of themselves as flourishing human beings and not just automatons on an assembly line, you might think they've actually enhanced the liberty of the workers. And then the question is, well, do you want courts to come in and say, because in a formal sense liberty has been reduced, regardless of what the facts on the ground as to the individual lives of the real people here are, because in some formal sense liberty has been reduced, we're going to strike this down and say it's unconstitutional? Or are you going to give some deference to the considered judgment of the democratic process that, in fact, some sorts of restrictions on bargaining power are actually in the public interest? That was really the question that the Lochner court was asking. Or actually do enhance liberty in some way that outweighs the restrictions to liberty of contract in a formal sense. And I would say on a lot of these questions, unless there's some good reason to doubt the good faith or the competence or the care of the legislature, and Tim, I know, can give us a lot of examples of situations where legislatures have done terrible things. You can have too much regulation. But I would say most of the time, the answer is yes, you can trust the democratic process. And it actually leads us to good results, and better results than we would get if we tried simply to promote a formal liberty of contract.
Great. So Tim, Kim says we can trust the democratic process more than we can trust courts to choose among competing policy preferences. And in this sense, he's sort of channeling Justice Oliver Wendell Holmes. And you have a riveting and accurate account of how Justice Holmes, who goes off to the Civil War as an abolitionist, he's imbued with his mother's idealism, is at Antietam. 17,000 people dead, 23,000 dead or wounded. He himself is wounded and almost dies. And he loses all faith in abolitionism and ideals, and he becomes such a nihilist that he believes that the strong have to be allowed to impose their will on the weak through the democratic process, because if they can't do it through law, they'll do it through violence. But he doesn't have any faith, as you say so accurately, that these are good laws. He says, I loathe the thick-fingered clowns we call the people. He's an aristocratic nihilist. He's not a progressive at all. But in Holmes's view, and in his famous dissent in Lochner, he said, as Kim just did, the Constitution is made for people of fundamentally differing points of view. The Constitution does not enact Mr. Herbert Spencer's social statics, this incredible line. He cites this creepy or inspiring, depending on your perspective, libertarian social Darwinist, whom Holmes himself actually embraces, but he's saying we shouldn't impose a social Darwinist view at a time when the New York legislature is embracing a progressive view. You disagree strongly, Tim. The point of your book is that a constitution can survive only among people who agree on basic precepts regarding political authority. You don't agree with Holmes that it's made for people of fundamentally different point of view.
No, I would regard that as the most untrue statement ever uttered in a Supreme Court opinion.
Where in the founding do you get your confidence that people have to agree that the libertarian rather than the progressive policy view is the correct one and the judges have to enforce it?
The Declaration of Independence. The Declaration of Independence says what it is that constitutes us as a people, which is why I say it's part of our Constitution and part of our law. When you read the Constitution, the first words in the Constitution, we the people of the United States. Well, who is this people of the United States? It's the same one people who have dissolved their political bands which have connected them with another people in the Declaration of Independence. And I contend you can't understand the Constitution without the political philosophy framework that is written into and gave rise to the Declaration of Independence. This argument, incidentally, is very similar to an argument that was put forth by a legal philosopher named Ronald Dworkin. And I'm ashamed to say I wrote the book before I had read Dworkin. But Dworkin makes this very similar argument by saying, what is it that we do when we interpret a constitution or a legal document? We read it in the light that serves the best political principles, and those principles, in the Constitution's case, are articulated in the Declaration. That's what makes it so that it's not judges just imposing their own personal views. They're imposing the political philosophy that is part of the Constitution in the form of the Declaration. Now, in terms of democracy versus liberty, this plays out as follows. Professor Roosevelt mentioned my opening passage where I quote Lincoln with this wonderful analogy that Lincoln uses between wolves and sheep. He says, the shepherd drives the wolf from the sheep's throat, for which the sheep thanks the shepherd as a liberator, and the wolf calls him a tyrant. Now, Lincoln's point is not to say that the wolf's view of freedom and the sheep's view of freedom are equivalent. Quite the opposite. We are all sheep in the sense that we own our own lives and we have the right not to be attacked, not to have our resources and our freedom and our things taken away from us. None of us have the right to be a wolf. None of us has the right to be a predator and to take away another person's freedom. The wolf and the sheep are not morally equivalent. The political philosophy on which the Constitution rests sees us all as basically free, and nobody has a right to be a wolf. Our right to restrict other people's freedom exists only so far as there is legitimate reason to protect ourselves against other people harming us. So I have the right to stop somebody from defrauding me or stealing things from me. But I don't have the right to tell him where he can live or whom he can marry or what he can say or what kind of business he can start and that sort of thing, because I have no right to be a wolf. In the Lochner case, these principles become crystallized. Incidentally, I love Lochner. My license plate is a case citation for Lochner.
How'd you get it? You had to fight David Bernstein for it.
Can you believe it hadn't already been taken?
Oh my God, talk about vanity plates. I know.
Here's a hint, though. The word Lochner would also fit if any of you are interested. Anyway,
you could abbreviate
what
it.
happens in the Lochner case? Here's a case where the government of New York says you're not allowed to be, in a bakery shop, you're not allowed to work as a baker more than 10 hours a day. Okay, now I think it's fair to say nobody in this room would want to be a baker in New York City in 1905. Awful work. Terrible. Hot, miserable work, right? Long hours. And yet, here's this German immigrant named Amon Schmitter, and he goes to his boss, Joseph Lochner, at the Lochner Bakery shop in Rochester, New York, I believe it was. And he says, I'd like to work more than 10 hours a day. And Lochner says, I'd like to let you. And they shake hands, and there you have it. Two grown adults who own their own lives and have the right to decide what to do with their own bodies, and it ain't nobody else's business if they do. Why would Amon Schmitter want to work more than 10 hours a day? No, because he's being exploited by evil capitalists, right? Now, of course, as my friend David Mayer says, the baker wanted to work overtime because he needed the dough. Right? And they get charged for violating the Bake Shop Act, and it goes up to the Supreme Court. And the Supreme Court says, you know what? That's right. And they're not hurting anybody else. They have the right to do with their own bodies what they please. If they decide to work more than 10 hours a day in a bakery and the other guy to pay them, they have the right to do that. And the government can only restrict that freedom if there's good reason, and there's no good reason here. Now, transform that case 100 years into the future, and you have Lawrence versus Texas. The state of Texas says, we as a state have the right to dictate to others whom they can go to bed with. Right? And the state of Texas sends armed agents of the state into people's bedrooms to drag them from the arms of their loved ones because the majority doesn't like the way they make love. And thank God the Supreme Court said, that's unconstitutional. They have the right to do with themselves what they please, and it ain't nobody else's business if they do, as long as they're not hurting any other person. That's the principle that I say underlies the Constitution, the principle of liberty.
Wow, okay, so this is very powerful and accurate. Tim has just said that don't be too quick to reject the economic judicial activism in Lochner, because that same philosophy of interpretation leads to the protection of the rights of gay people in Lawrence and Texas. And he's absolutely correct about that. And Justice Anthony Kennedy, who today embraces something closer to the natural law philosophy that you're embracing, both voted to protect gay people, LGBT citizens in Lawrence, and also to strike down the health care mandate in the Obamacare case, invoking similar notions of autonomy and economic freedom. So, Kim, given the fact that judicial activism can sometimes lead to liberal as well as conservative results, and that it is endorsed by philosophers like Ronald Dworkin. Look at these strange bedfellows here, ladies and gentlemen. The libertarian Tim Sandefur just invoked as his constitutional model the great liberal political philosopher Ronald Dworkin, who said you have to pick an overarching philosophy and interpret the Constitution in light of that, and you can't engage in constitutional interpretation without a philosophy. Kim, given this incredible liberal pedigree, Justice Kennedy, Lawrence in Texas, Ronald Dworkin, do you still believe that there's a myth of judicial activism?
I do. I do. I know it's astonishing, but I do. Well, that was a wonderful statement by Tim, and it inspired a couple of thoughts on my part. One is this. So this idea that liberty is the right of consenting adults to do whatever they want with their bodies and make whatever bargains they think are in their interest. That's a nice idea. I don't think that's the Constitution's idea of liberty. And I'll tell you why not. So when I think about the Constitution, the heart of the Constitution, I don't think about the founding for reasons that I sort of explained before. Basically, I think the founding Constitution failed. I think it came apart in the Civil War, and I think that the Reconstruction Constitution is a different Constitution, and in fact, a better one. So when I'm trying to think about our deepest constitutional values, who we are as a people, I look at the Reconstruction Constitution, the Reconstruction Amendments. And in fact, if you ask people, if you think about big Bill of Rights cases, if you ask people, give me a case that defines our understanding of the Bill of Rights, they'll frequently say something like Miranda, right? Fifth Amendment, right to remain silent. Gideon v. Wainwright, Sixth Amendment, right to counsel. Or maybe New York Times v. Sullivan, First Amendment. In fact, those are not Bill of Rights cases. Those are 14th Amendment cases. This is why I say the Reconstruction Constitution is really the Constitution we have. So, if you're thinking about liberty and the Reconstruction Constitution, well, you can look to the 14th Amendment, Privileges and Immunities Clause. You could also look to the 13th Amendment. What is the core paradigm violation of liberty? The worst thing from the perspective of the Reconstruction Amendments? Slavery. Now, what is slavery? Is that the government enslaving you? Is that the government saying that you can't strike whatever bargains you want? In some forms, sometimes yes, but not entirely. 13th Amendment means you cannot enslave yourself through whatever contract. The 13th Amendment has in fact been used to limit liberty of contract. So consenting adults who know what's best for them enter into a contract for personal services. The person who's supposed to render the services then doesn't want to perform. Can you compel them to live up to the terms of that contract that they voluntarily signed, knowing what was in their best interest? No, you can't, because it's too close to slavery. So when I think of liberty, I think of more maybe something that has to do with human dignity and autonomy and human flourishing, and not just this formal idea of liberty of contract. Now that said, liberty is important. The liberty of consenting adults to do what they want with their bodies, I think that's an important value. I think the Constitution protects it. I think the legislature cannot restrict that unless it has some good enough reason. But how distrustful I am of the legislature and how demanding I'm going to be in saying to them, what is your reason for this? It depends on the context. And I'm going to give the legislature a freer hand in regulating relationships between bake shop owners and employees, where actually I have a fear that, yes, the employees are being exploited. And I think if you look at maximum hour and minimum wage laws generally, on the whole, I'm not sure about the facts of Lochner, but if you look at them on the whole, I think that the employees like them. I think the employees would rather have these minimum wage, maximum hour laws. So I'm going to give the legislature a freer hand there. I do not trust the legislature to make sensitive, sound decisions about the private sexual activities of gays and lesbians, because there's a history of prejudice, because this is a group from which it's really impossible to exit. For lots and lots of reasons, I think it makes sense to treat economic regulation differently from regulation of the private sexual behavior of historically persecuted groups.
Great.
I'm going to look in here for...
You can do it, but I'll right. Ask the question and then you can answer the one you actually want to answer. But
he knows lawyers well.
You don't find in that pocket constitution, which I should say, we're handing them out today, but they should be available for sale on Amazon soon, C-SPAN audience, so all of you can read this thrilling essay from the Declaration to the Bill of Rights. You're saying there's no distinction between economic and personal rights in the Constitution. Right. Kim has just defended treating infringements on personal autonomy more skeptically than infringements on economic liberty. Tim says there's nothing in the Constitution that contains that distinction, and that's a good debate to have. But Kim, I want to press you on your notion that judges have a blank check to decide not what rights violate specific provisions of the Bill of Rights, but generally to decide what laws are arbitrary and not in the public interest according to natural law philosophy. Your standards for arbitrariness are pretty vague. You say it's not an easy word to define, but a law has to have a rational explanatory principle. It can't have no relation to a legitimate purpose or goal or lack any reasons to support it. In Lochner, there was a reason. They said it was bad for bakers. And Justice Harlan, who unlike Justice Holmes was far less of a judicial nihilist, said, look, I'm not sure whether it's good or bad for health, but there are plenty of people who are smarter than me, who the New York legislature concluded did think it was bad for health. And as a judge, it's my job, in the face of uncertainty, of contestability, to defer to the political process and not impose my own sense of whether or not it's bad for health on America. And you can see that the opposite presumption, where judges actually are empowered to do what you want, which is to decide which laws are arbitrary and which aren't, would vastly call into question the regulatory state. And you honestly and candidly say that the reason that judges in the slaughterhouse cases didn't want to construe the Constitution the way you want is because it would call into question an awful lot of regulation. And you also concede that since the New Deal, much of what the government now does, health and safety regulation, minimum wage laws, maximum hour laws, all of those might have to be invalidated by courts. That's why some critics of your constitutional vision, the tradition you represent, say that this is a recipe for mass judicial activism, and that's why I don't think a single member of the Supreme Court, any of the conservative justices, not Scalia, Thomas, Roberts, or Alito, embrace it. In fact, they explicitly reject it because they think that judicial deference is the way to go. And Chief Justice Roberts in the healthcare case invoked Holmes, who's his hero and your enemy, and says that in the face of uncertainty, there should be deference. So why are you so confident that judges are equipped to strike down the entire regulatory state?
Well, I'm very comfortable with the label of radical. And if my, which I believe is the correct interpretation of the Constitution, were put in place, and if that led to the striking down of the regulatory welfare state, I see that as a feature and not a bug. The vast majority of what the government does to us today is unconstitutional, deprives us of liberty without sufficient justification, and exists largely to satisfy established, well-connected political elites at the expense of those of us who lack the political influence necessary to get the legislature to do favor for us. Instead, we have to rely on the Constitution to defend our interests. The reason we have a Constitution is so that we don't have to spend our time lobbying the government to respect us. You know, Costco, the nation's leading abuser of eminent domain, has people whose only job it is to go to city councils and persuade them to condemn people's homes and give the property over to Costco so it can build a shopping mall. Now you don't, to most of the people in this audience, don't have the resources necessary to persuade the city council not to steal your home and hand it over through eminent domain and redevelopment. That's why we have a Constitution, so that you don't have to spend your time doing that. You can go about spending your daily life pursuing happiness instead. So I see it as a feature and not a bug if the Constitution's enforcement led to restraining and tying the hands of legislators. That's the purpose of the Constitution, and I'm very proud of that. Why I would entrust judges to make these calls is a much more complicated question, because I agree that standards like lawfulness as opposed to arbitrariness are rather broad standards, and they call for judgment calls. They call for the use of political philosophy. I think conservatives particularly are guilty of trying to come up with a constitutional theory that will avoid difficult questions of political philosophy. They think that they can come up with some sort of, I don't know, mathematical equation that will resolve these questions without resort to questions of political philosophy. And I don't think that is proper or possible. I embrace political philosophy as having a role in the judicial process. I just argue it's the political philosophy expressed in our founding documents, in the Declaration and in the Constitution. As for trusting judges, that's why we have a process for appointing and confirming judges and impeaching them if necessary. All government, as Madison said, lodged as it is in human hands, is liable to abuse. And that's just a flaw, if you want to call it that, in any system that purports to be, well, I was going to say purports to be democratic, but of course monarchical or anti-democratic systems have this problem even more, in that they have no way of correcting the mistakes of their leaders. In the previous talk, Mr. Levin made a great point when he said the Constitution presumes that we're all wrong, and then says, what would a good government look like assuming we're all wrong? And that's right. That's exactly how it should be. Judges should be much more willing to strike down laws as unconstitutional. In the past several years, judges have struck down a fraction of 1% of the laws Congress has passed as unconstitutional. Does anybody in this room think that Congress gets it right that often? Right? And so, yes, it is true that a judge is liable to abuse power. There's plenty of cases of judges abusing their power. That's just why we should impeach them when they abuse their power. But I don't see that as being some sort of proof that my theory is wrong. All systems will, in the end, as Tocqueville says, in the end, all governments rely on the good sense of the people. And if the good sense of the people isn't there, then no constitution of any sort is going to succeed.
Great. So the argument is squarely joined. It is principled and candid of you to embrace the label radical, to say that your theory really would lead to the mass invalidation of a great number of laws.
Which I like to call liberty.
The enforcement of liberty. Kim, you are skeptical of this massive exercise in judicial activism. Tim groups you in very distinguished company with Justice Stephen Breyer and Judge Robert Bork. And he says that Breyer, Bork, and Roosevelt see the Constitution as concerned primarily with fostering democracy and enabling the majority to create its preferred society through legislation. Very honorable company there. But it reminds us that really Judge Bork, like Justice Breyer, embrace judicial restraint. And there's a serious division among conservatives between, you call yourself a judicial activist like Tim, who would unapologetically use the courts to strike down much of the regulatory state, and judicial restraint conservatives like Justice Scalia, Judge Bork, And I think even Justice Thomas has rejected the idea that
Some
the
degree.
Declaration of Independence should be judicially enforceable. So you don't have a single real ally on the court, except perhaps Justice Kennedy is more sympathetic to a Constitution of Liberty, but does not embrace the idea of unenumerated natural rights being enforced. So I ask you, Kim, as along with Bork and Breyer, the leading critics of Tim's view, you have 4 reasons that Tim attacks for why this would be constitutionally disastrous and is not merited by either the text or history of the Constitution. Why don't you give us some of those reasons?
Well, I don't think of myself as an advocate of judicial restraint necessarily. Because, I mean, if you look at sort of the mistakes the Supreme Court has made, so, you know, we're trying to figure out what should the court do. We're going to look back at history maybe and ask what are the bad things it did in the past. The answer is sometimes it does a bad thing by being activist and striking down a law that it shouldn't have struck down. Maybe Dred Scott is an example of that. So the Supreme Court thinks we're going to behave aggressively, we're going to solve this slavery problem, we're going to avert the Civil War, and they end up issuing a terrible decision which history has justly reviled. But deference can look bad too. So Plessy against Ferguson. The Supreme Court upholds a Louisiana law requiring railroads to segregate their cars by race. Or Korematsu against the United States. The Supreme Court upholds the government's plan to evacuate Americans of Japanese descent from the West Coast. So I'm not saying judicial restraint is the best thing or that courts should always be restrained. What I'm saying is courts interpret the Constitution and courts can ask whether what the legislature or what the executive branch has done complies with the Constitution. But the legislature can ask that question too. Is this law constitutional? The executive branch can ask that question too. And the fundamental question that we need to be thinking about is when are the legislature and the executive going to do a good job of answering that question, and when are they not? When should courts be deferential? When should they be suspicious? And I believe there's a certain set of factors out there, and I try to list some in my book. People can come up with others. I'm not wedded to any particular list. I'm wedded to the idea that in some circumstances it makes sense for courts to be deferential, and in some circumstances it makes sense for them to be suspicious, which is why Tim actually wins me over when he talks about the predatory corporations or the wealthy and powerful dominating the legislatures and enacting laws that oppress the politically weak. That makes me want to say, hey, yes, show me that that's happening, and I will say courts should step in, because in those circumstances you can't trust the legislature. Now, I see the court has done this in the past for racial minorities. I think that makes a whole lot of sense. Can't trust the legislature. It's done it for women. It's doing it with respect to sexual orientation now. And if we could come up with some nice, judicially administrable way of looking at political power as it relates to wealth and access, I'd do that too. I think inequality, wealth inequality leading to inequalities of political power is a terrible thing, and I would love to have courts do more to address that if they could. However, I'm a little bit suspicious that the libertarian agenda actually goes a lot farther than that, and that they are possibly after the whole regulatory state, which I do not think is in its entirety a creation of crony capitalism.
They are. Tim openly said that that's the goal, is to strike down much of the regulatory state. And the regulatory state was not only a creation of crony capitalism, but also, in part, of my judicial hero, Louis Brandeis. And whenever I have a hard constitutional question, I ask a simple axiom, WWBD, what would Brandeis do? And I mention this now because, Tim, you lump Brandeis and Holmes in the same sentence. You say both were advocates of radical judicial abstinence. Not fair to the great Justice Brandeis, unlike Holmes, who had contempt for what he called the thick-fingered clowns we call the people, and almost never voted to strike down any law, even the most illiberal in American history, including, as you say, Buck v. Bell mandating sterilization. Brandeis was far different. He was generally deferential in economic matters because he believed in the states as laboratories of democracy, like a good small c conservative, and thought that small communities were well able to govern themselves. He hated the curse of bigness and large corporations and wanted to defend small business people against J.P. Morgan, but he was quite willing to strike down laws and to defend liberty when they infringed textually enumerated provisions of the Constitution. So he was the greatest defender of free speech and the greatest opponent of unreasonable searches and seizures, and the greatest defender of privacy in the 21st century. So I give that plug to Brandeis just because I think you were a little too quick to lump him in with Holmes. And he's an example of a justice who will both enforce textually enumerated rights, but generally be deferential when it comes to other laws. We have just a few minutes for questions from our great audience, and Tim, here's the first one for you. How do we account for the value of equality in the Declaration? How does that impact the idea of liberty?
Well, in some ways, equality is more important than liberty as far as the Declaration is concerned. In this sense, what I mean by that is, the reason we are free, the reason we own ourselves, is because no other person has any prior right to own us and to control us and tell us how we may live our lives. Jefferson put this point very beautifully in his very last letter when he said, "The mass of mankind has not been born with saddles upon their backs, nor a favored few booted and spurred, ready to ride them legitimately by the grace of God." Because people aren't born with some people with saddles on their backs and other people with spurs on, we all are equal in the sense that we have the equal right to run our own lives, which is why we have a right to government by consent, right? You don't consent to the government by your parents, because you're not equal with your parents. But you are equal with your neighbors, and so your neighbors have no right, no primordial presumptive right to control your life, and therefore they have to ask your permission first. Government by consent comes out of that principle of equality, according to the proper understanding of equality and liberty as articulated in the Declaration. What the progressives managed to do, people like Brandeis, what they managed to do was to substitute democracy for liberty as the central value of the Constitution. The Constitution, in its first sentence, declares that liberty is a blessing. That's the word it uses. Liberty is a blessing. It doesn't say the same thing about democracy. In fact, it uses the word democracy not once in the entire Constitution. The reason we have democracy is to protect liberty, not the other way around. The reason why I dislike Brandeis so much is because what Brandeis managed to do, although he purports to be a defender of free speech, what he does is he recharacterizes free speech from the essential Madisonian perspective we talked about earlier today, that I have a natural right to speak my mind and nobody has the right to take it away, transforms it into a democratic privilege, that the reason why we have free speech is so that democracy can flourish and work. So now free speech is a privilege that is given to us by society for society's own purposes.
I have to defend the honor of my hero because he said the opposite. He said free speech is both a right and a privilege. The hardy men who made our constitutions were not cowards. They understood that the freedom to think as you speak and speak as you think is among the duties of civil society, but if there's any principle that undergirds the Constitution, it's the necessity of public discussion, and unless there's no time for discussion and there's an imminent threat, then speech has to be free. There's no circumstance where he suppressed speech in the name of the community. He believed simply, like the Romans, who were the ancient Athenians of 5th century Athens, and like the Jeffersonian shires that he thought were models of an engaged community, that speech was both a right and a duty.
But I defend the right not to be engaged in your community if you choose not to be.
I don't think he would dispute it. He would just defend the right of anyone to speak. But well, actually, why not? I think a little debate about the central meaning of Brandeis is not a bad place to end this panel, which, like all Constitution panels, must end on time. Ladies and gentlemen, we have one last installment of this blockbuster constitutional book fair. We've talked about the First Amendment. We've talked about Paine and Burke. We've just had a great debate about the libertarian versus democratic vision of the Constitution. And after a 15-minute break, we'll come back and hear a new biography of the great Chief Justice who solidified the vision of the court as a co-equal branch of government, John Marshall. Please join me in thanking Tim Sandefur and Kim Roosevelt.
Excellent. Well done. Thank you so much.
Excellent job.